Good morning. I'm going to take you back to your place of nativity where all your unalienable rights were stripped from you, unbeknownst to you, as you were indoctrinated through a public education system that wanted you just intelligent enough to punch in the clock at 8 o'clock and punch out at 5 o'clock and think that a beer at happy hour was freedom, all right? So at that moment of your known existence to your fellow brothers and sisters, your fellow man, was the moment in time where you had all of your unalienable rights intact, okay? And through false and deceptive and misleading trade practices, documentation, presumption and assumption, we have slowly contracted away our rights for privileges, okay? It's not a secret. Contract creates the law, equity follows the law, and for all intents and purposes, the United States, the corporation, Title 28, 3002, 15A, for all intents and purposes, it is lawless until you make the contract, okay? And there's some ways to fix this. Of course, for many people that are in debt, it's extraordinarily hard to truly enjoy what is known as freedom. You can't have debt, all right? And you have to overcome what creates value. We hear the term money thrown around so loosely anymore, but nobody really knows what it is. And the people that do know what it is don't comprehend how the system works. And so through a lack of knowledge, we're easily manipulated like cattle, like sheep, okay? Because we don't know any better, so we just follow everybody and what they're doing. And truth be told, it'll get you in trouble a lot of times. So what the corporation has done is made it really easy for you to contract away your rights, enter into contract with them, and then they'll lord over you, okay? And they made it very, very easy to do that. Extraordinarily hard to make it on your own. At the moment you were born, you had all your rights, and they were of the highest, the purest form, unalienable rights, and status that are enforceable in a court that exists nowhere else in history of the world except the United Union of States of America, okay? The United States of America is a genius but costly established private trust, mortgage arrangement established under the rules of equity, chancery signed by multiple joinder and witnesses, intended for the posterity, and its safeguards, secures and protects your unalienable beneficial rights coming from the Creator, all right? And unfortunately, through our ignorance and our neglect, nobody also told you that private trust, chancery practices, and laws, not commerce, not commercial, govern the essence of the entire Western world since Jesus Christ brought the new covenant. And the best news is that you can enforce these rights today from your private personal conduct all the way to the Supreme Court of the United States. All right, now this takes a lot of due diligence, a lot of effort. Anybody that's telling you that they've got a clear-cut path, a clear-cut way, I'm here to tell you with all my firsthand knowledge and experience, there is no clear-cut path. There is no surefire way. You have to carve and blaze that trail on your own. You have to be able to stand with conviction. But part of that is understanding trust and trust law, and why trust law is the highest law in the land. Just think about it for a moment. Would you drop off your offspring with somebody you didn't trust? No, which means trust law is in fact the highest law in the land. They say that the Constitution is the law of the land, but in all actuality, treaties supersede the constitutions, okay? And we've seen it time and time again in Summa Court versus the state of California. And I mean, there's 180 years of case law when studying land patents that treaties supersede even the Constitution, not only of the state, but also of the United States of America. So we start to evaluate treaties. What are treaties predicated upon? Treaties are predicated upon trust. the belief that one party will do as they say they're going to do in order to preserve the posterity of the agreement, right? Once that trust is gone, without trust you have nothing. There's no going back. Once the trust is gone, it's almost irrevocable or revocable. Once you lose that trust, it's very, very, very seldom that you can rebuild it again, at least to the standard that it once was when you blindly trusted somebody, right? Same principles here. So everybody that says, well, the Constitution is the law of the land, not necessarily. There are other things that govern the law of the land. First of all, natural law, ecclesiastical law. These law forms, these jurisdictions supersede. So a lot of officers, when I talk to them, they go, so Derrick, you don't think the laws apply to you? It's quite the contrary. I operate on a set of laws that are much higher than the statutes, codes, city ordinances, and provisions that you operate under, right? I have a higher moral calling and comprehend completely what the law is, all right? And I will always do my best to remain lawful. And if by some mistake or happenstance I should step out of line, I will always be quick to try and administer remedy. We've seen that in the YouTube videos with myself and the DMV. All they had to do was give me an order. I don't work for free. Involuntary servitude shall not be had. I'm not a freaking slave. And if you want me to do something, I have no problem following an order, but you're going to fix your wedding signature to it because I don't work for free and I'm going to bill you for it. So, of course, they've never come forward with their claim. And they're not going to, because I'll wrap them up so damn tight it won't even be funny. And I'll absolutely hold them liable for it. And they know that. And once you get to that point in your life, these actors who are hell-bent on fleecing you will stop. All right? But we have to understand the new covenant, what it meant. The blood of Jesus Christ being shed was for all sins. Sins and debt are synonymous with one another. The symbolism also showed us something very, very important. From where you once came, you will soon return. Okay? So all the energy always returns to the source. So if you create a promissory note, right, and you lend the bank your credits on account that you manifested into existence, those credits on account always return back to you. That's the symbolism of Jesus standing in his surety and his blood running back into the soil. That was the life source energy. That's the labor. That's the gold, if you will. And come to find out through my due diligence and research, there's a thing called anatomic gold, and it's actually in our system. There's been scientific studies done in the cranium where there's actually pockets of gold that can develop, which was pretty interesting, I found. It's not a significant amount, but it's there, which is very interesting. So let's get on with this. And the best news is that you can enforce these very rights today from your private personal conduct. Remember, everything's about conduct. Everything's about trust, whether it's implied trust, resulting trust, your actions create a trust, your contracts create a trust relationship, and it's just a matter of just wrapping your head around it. And then, of course, you can have your own private trust set up, but there is a public trust set up for your benefit as well. But you have to comprehend what happened in 1933. Okay, and even before 1933 and 1871, the Reconstruction Act, and before 1871, you had Abe Lincoln who made a declaration of war and never made a proclamation to end the war, and only the president can make the proclamation. Because that proclamation was never made before they suicided him, they Clintoned his ass, because that was never made, from that point on and forward, we've always been in a time of military occupation, okay? So that shouldn't be too hard for you guys to wrap your head around. And to prove my point, every year since then, the alleged president of the United States Corporation has, in fact, every year, a ritual, if you will, signed off on an executive order declaring a national emergency. Okay, now there's multiple national emergencies. We're always at war. If we're not at war with poverty, we're at war with drugs. If we're not at war with drugs, we're at war with DUIs. We're at war with invisible enemies. We're at war with invisible viruses nobody can seem to prove exist. Statistically proven, in 2017, 18, and 19, all the years statistically had more deaths than 2020. So you tell me how bad this invisible boogeyman is that's got everybody spooked. Another thing you should probably be paying attention to right now is the people are starting to come together, and they're going against the elites, which I think is brilliant the way they're doing it with the stock market. Pay attention to what's going on there, and maybe look into getting yourself some gold and silver. Physical, solid assets are always going to be more valuable than a piece of paper. At the end of the day, if stock market closes or shuts down or whatever, that piece of paper isn't going to do you any good. Just like if you have a safety deposit box at a bank, I'm going to tell you this right now. In 1929, for those of you that weren't studying your history, in 1929 when they closed down the banks, okay, the people were not allowed back in to get their stuff because possession is 9/10 of the law. The other 10th is title, okay? But do you think any banker is going to go down there and risk being euthanized to allow you to get into your safety deposit box where your gold and silver or whatever else is in there, your ammunition, whatever the heck you keep in there? It's none of my business. But do you honestly think that during an economic collapse that some banker is going to come down there and open the bank for you so you can get your stuff? Bullshit. It didn't happen in 29, and it damn sure won't happen here in the near future. So, just a word to the wise, while you can, maybe go invest in a safe and put it somewhere, be discreet about it, and put all your belongings that were once in your safety deposit box at a bank that you thought you could trust. And remember, history teaches us over and over and over again that it repeats itself. Why you would blindly trust these bankers as though they're going to take good care of your physical assets when they're imploding the system again, just like they did in 1929. However, also since that day of your nativity or naturalization, operating upon you with or without your knowledge are only two competing realms of law. All right? There's the at law or inequity. That's it. The written law versus the unwritten law. So the enumerated amendments versus the unenumerated rights. Okay, you had the enumerated rights and the unenumerated rights. Okay? The enumerated laws versus the unenumerated laws. The fictional realm versus the substantive realm. Substantive would be your substantive unalienable rights. Okay? And remember, if you're at an at-law venue, not in-law venue, your substantive rights are always a cause for an interlocutory appeal. And an interlocutory appeal does not require a summary judgment or a declaratory judgment needing to be filed in order to uphold your substantive rights. The at-law versus the equitable jurisdiction. As your instructor, my objection during the next 2 days is that you recognize the two realms distinctly and benefit gloriously from this awareness and skill. On the one hand, there is commerce, war powers, public, at-law, and on the other hand, there is equity, private, substantive, unalienable doctrines and principles, sound doctrines and principles. It is about understanding new laws and guiding principles from a massive established volume of jurisprudence called equity. This realm shall be your new realm as a practicing unincorporated private citizen of the United States and private member of one of the Union member states, privately residing and privately domiciling without a federal zone within a non-military occupied private area, not subject to the jurisdiction of the Roman military municipal United States. Now, that was a mouthful. There's some things within this literature that I don't agree with after extensive studies, but again, I'm not going to alter it at this point. I don't agree with the word citizen at all. I'd rather just be a man, private being the adjective in front of the noun. I'd rather just be a man. In the beginning, our heavenly creator created man, period. And so that would be, as far as the ecclesiastical side, the living soul of the man, the first breath of life, the most powerful position in my comprehension and understanding that you can hold. And of course, there's two realms. The other side of that jurisdiction would be the natural person on the legal side, which is the highest position you can hold on the legal side of things. All right? Definitions of winning, private decree, be it in any state or federal equitable jurisdiction, equity history. Aristotle, equity. Aristotle had said, equity is the correction of the general words when the matter falls outside their senses. Okay? Equity will not aid a volunteer, however, equity will assist the legally disabled. And so when the at-law side falls out of its senses, which is what they do every day by fleecing good people for their lack of knowledge, that's where we come in with equity. And remember, in order to get into equity, if you make sure that it's always an issue of property, the doors to equity shall open up. All right? Because equity will take over to avoid a multiplicity of suits. These are maxims I'm speaking of, and I've got them memorized in my head from a long time of studying. But if you just hearing the words of that I'm speaking, it will make very, very clear sense and hopefully provide clairvoyant thought for you as to comprehending why this is so important. And another question to ask yourself is, why weren't you learning this in school? If law is so important, it's such an intricate facet of our everyday life, so important to the fact that we've got to have agents and agency out there all the time enforcing it. Don't you think you should be learning this stuff in school when you were younger? It's just a food for thought. Joseph's story, thus Aristotle has defined the very nature of equity to be the correction of the law wherein it is defective by reason of its universality. Bible, the New Testament, New Covenant, the story of the stoning of the adultering woman. Jesus used the God-conscious mind to judge not the common law, Pharisees, or Roman martial law. The law of first mention from Matthew 3:15, the first use of the word righteousness from the Greek dictionary meaning equity of character or act, specifically character, justification, righteousness. In Ecclesiastical 2:21, equity. Now remember, when we're talking about Jesus and the stoning of the adultering woman, remember what he said. Let he who has not sinned cast the first stone. And when we think about the equity that was exhibited, Jesus would have been the only one that was free from sin that could have cast a stone and did not. All right? So that just goes to show, the parable within that. None of us are free from sin. None of us have the right to judge one another. Absent a crime, there is no victim. So what are you doing in these public venues? Where's the international contract you entered into? Where's the injured party? The one making a claim saying they're harmed, injured, damaged, and lost. Under the Sixth Amendment, right? The Sixth Amendment is firmly put in place to keep the government from encroaching on your right, your unalienable right to face your accuser. But yet we see it day in and day out where they just run amok over people, and never, ever, ever is that topic brought up. Remember, the Constitution grants and coffers you no rights at all. That's a fallacy. And for the people that speak that way, I really feel for you, because I myself used to speak that way, and I used to have judges snicker at me because they knew I didn't know what I was doing. They felt safe in going ahead and commencing a fleecing, knowing that I probably wouldn't be able to attach myself to them and hold them liable for their actions. And so the teachings that I'm bringing forward to you will help you be able to assert yourself in a manner, a conduct, if you will, that will help express and expose the implied trust, the resulting trust, and be able to assist you on your way. That's the importance of those maxims, because those are just ways of planting seeds in your mind to get you to start cognitively thinking outside the box. In Ecclesiastes 2:21, equity, or casher, a prime root proper, to be straight or right, by implication to be acceptable, also to succeed or prosper, direct, be right, prosper. Proverbs 1:3, to receive instruction in wise behavior, righteousness, justice, and equity. Proverbs 2:9, then you will discern righteousness and justice and equity and every good course. Psalms 98:9. For he cometh to judge the earth, with righteousness shall he judge the world, and the people with equity. All right? Which is what your high Baal priests are supposed to be doing. But unfortunately, through the perversion of the law, being the fact that All of them are now administering a bankruptcy. This is global, ladies and gentlemen. It just doesn't pertain to the United States. This is everywhere. All right. The whole world of commerce, which is the world of war, functions off hypothecated credit, signatures, letters of credit, bills of particular, promissory notes, negotiable instruments, international bills of exchange. Okay, this is how the world of commerce really works. Announce that I am free of all the charges against me. Only you can see into my heart to know that to be true. Treat me with fairness. Look at me with justice. Psalm 17:2. I keep telling you how important this good book is here. This good book is so powerful. All right, I've had lawyers chase me out of courtrooms before to tell me how incredibly powerful this book is. And I go, oh, trust me, I know. Keep reading it, Derek. This book that's the best book in the world. I know it is. Okay, and they know it too. The older lawyers recognize that book and realize it. Some of these younger ones that are just coming out of law school, they don't have a freaking clue what's going on. I'm telling you, the ones that got 40, 50 years into it, they know. All right. There's a famous lawyer, Jake Ehrlich, okay, and he talked about the birth certificate and everything else. He once won an entire case using nothing but the 1611 King James Bible. He wrapped it with another cover so nobody would know what he was reading out of, and he won the entire case reading out of this book. So you just let that resonate in your mind and distinguish how powerful the words within here really are, okay? Let my sentence come out of your presence. Let your eyes look on to equity, Psalm 17:2. Psalm 72:2, may he judge your people with righteousness and your afflicted with justice. May he vindicate the afflicted of the people, save the children of the needy, and crush the oppressor. For he will deliver the needy when he cries for help, the afflicted also, and him who has no helper. Sometimes the same words is rendered in one version equity, and in another uprightness. Psalms 111:8, or justice, Psalms 89:14. John Bouvier, Institutions of American Law, 1882, Volume 2, subsection 3724, Part 4. The law is nothing without equity, and equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have a weak perception of right and wrong. And again, we turn to 1 Timothy subsection 9 to substantiate what John Bouvier is saying in 1882. Okay, these men were very, very spiritual. They were very well connected. They didn't have boob tubes. They didn't have YouTube. They didn't have all this propaganda crap. They didn't have radios and music and all that other stuff that was clouding and polluting their mind by the evil Jesuits who have systematically designed this to take you to hell. And they really have. I mean, they've designed the system so you'll throw morality out the window, you'll throw ethics out the window, you'll breach trust every time you get an opportunity to. They've bred into a selfishness and done away with self-reliance. Everybody needs to rely on somebody else. They don't even teach how to change a damn tire in high school anymore. I mean, these are basic skills, life skills that you should have. And most kids that go through high school don't even learn any of that anymore. All right? But let's read on. So what Bouvier is saying is those who only perceive law as man writes it never see it as well as the equity that has been written on their heart. The men and women that have ascended of mind see it differently. Again, I'm not lawless. I'm far from lawless. In fact, I hold myself to a higher standard morally, comprehending the law. Okay? And I don't need the law of the Pharisees to dictate how I live my life because I'm not a heathen, all right? And I'm not without God, and I'm not without government, okay? I'm not anti-government at all. In fact, I govern thyself. And it's very clear what the Founding Fathers' intent was about the consent of the governed, and where do you think that came from? right here. So, let's read on here. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as the assistance for those who have a weak perception of right from wrong, in the same way that optical glasses are useful for those who are short-sighted, or those whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Remember how often I'm talking to you about the letter of the law versus the spirit of the law? I just need you guys to visualize that. I'm here, again, just to plant seeds to help you out. Equity exercises an exclusive jurisdiction in all cases of mere equitable right. That is, such rights are not recognized in courts of law. All right? Most of the cases of trust and confidence fall under this head. Its exclusive jurisdiction is also exercised in granting special relief beyond the reach of the common law. I keep telling you guys, the common law after 1935 is not what you've been told. It's not what you think it is. The common law is common to them, not common to you. Now, when we start to evaluate the lawyering craft, in their literature, they tell you that there's two classes of citizens. There's the first-class citizens, which is the lawyers, and they're privy to special privileges that you're not entitled to because you're not a club card-holding member. All right, and then there's the second-class citizen, a lower, inferior citizen who knows not what he's doing and needs to be lorded over because he is a citizen, which is a subject slave. He's a mental ward of the state of unsound mind, and he's incompetent. Okay, and you need to comprehend this is how they think about you. All right. Most of the cases of trust and confidence fall under this head. Its exclusive jurisdiction is also exercised in granting special relief beyond the reach of the common law. Ex equeo et bono is a Latin term which means what is just and fair, or according to equity and good conscience. All right. How many times have you been to court and seen, in good conscience, any of these actors act in good faith? Okay, the second they're telling you they're acting in good faith, yet they're operating under color of law is bad faith. It presupposes that anything they're doing is in good faith, all right? And it's a complete contradiction and oxymoron that you can hang your hat on, okay? Something to be decided ex equo et bono is something that is to be decided by principles of what is fair and just. A decision maker who is authorized to decide ex equito bono is not bound by legal rules, but may take account of what is just and fair. Most legal cases are decided on a strict rule of law, common law, okay? It's a very strict, rigid mold, okay? And if there's no remedy to be had there, even though you're entitled to remedy, but your case doesn't happen to fit that mold, then you get squat. And there's where man discovered equity. Knowing that there was something wrong fundamentally with the system, had to lean to their heart, their spirit, and their soul, and look at the difference between the letter of the law and spirit of the law and do what was right, just, and fair, which is ultimately, at the end of the day, justice. Okay? A decision maker who is authorized to decide ex equito et bono is not bound by legal rules, but may take account of what is just and fair. Most legal cases are decided on strict rules of the law. For example, a contract will be enforced by the legal system no matter how unfair it may prove to be. But a case to be decided ex equito et bono overrides the strict rule of law and requires instead a decision based on what is fair and just under the given circumstances. Maxims are rules or principles of law universally admitted as being just and consistent with reason. All right, sound principles and doctrines. They are sometimes like axioms in geometry. Many maxims are merely the statement, in short, of pithy sentences of principle which claim the assent of mankind. These existed before the law. For it has been well observed, nations have been found without laws, none without maxims. Such maxims may be considered as fragments of the natural law which was promulgated at the beginning of the world. Maxims of the law from Bouvier's 1856 Law Dictionary. Harris, civil law. An heir, one who succeeds to the whole inheritance. Okay? And remember, only the creator can create an heir. Heredem, ducis facet, non-homo. God and not man makes the heir. I'm not going to try and read the Latin anymore. It's just I'm going to murder it and it'll be horrible. So I'm going to stop reading the Latin and I'm just going to read the maxims. Heir is a collective name. Okay, H-E-I-R is a collective name. Heir is a term of law. Son, one of nature. An heir is either by right of property or rights of representation. An heir is another self, and a son is a part of the father. The heir is the same person with the ancestors, and the heir of my heirs is my heir. Now, when we start looking at land patents, we really start to see the heirs and assigns forever. It's huge when you start to comprehend what's really going on. And that's where I started to realize how powerful the heirs are. Not to mention, when you start to study trust law and you get into Genesis, you start to realize that you're an heir and assigned forever. Granted to you by the grantor, the Heavenly Father, you've been granted dominion to take care of this place, right? We're failing horribly. We're failing miserably, all right? We're following 503C1A churches and 508C1As, and these churches are bound to receive their benefits and privileges from the government by properly structuring society never to rebel. All right, does that seem godly? No. And in this good book, it tells you are to follow a God-fearing government. When in the history have we really had a God-fearing government? I read about it in this book that there were God-fearing governments at one point. I don't see them anymore. So you tell me. Are we failing horribly, miserably? He is the lawful heir whom the marriage demonstrates. The heir succeeds to the restitution, not the penalty. When two rights concur in one person, it is the same as if they were two separate persons. Bouvier's Maxims of Law, 1856. To make a law, there must be a superior who has authority to make it, and an inferior who is bound by it. To complete the definition of law, we must say that it is a rule prescribed by a lawful superior. God is the first superior. Institutions of American Law, Volume 1, 1851, by John Bouvier. I mean, the man was a genius, right? He was really in touch. He comprehended that God creates the heirs, and there must be an inferior and a superior in order for law to even work. Well, where do we get told what to do? Our Heavenly Creator tells us how we should be, and yet still gave us free will. Amazing, right? Henry R. Gibson, Citizen Chancery, 2nd edition from 1907. He was a chancellor in Tennessee, and he was of brilliant sound mind. He was the reason Tennessee flourished in equity. So Henry R. Gibson, December 24th, 1837 through May 25th, 1938, served as a state chancery court judge and was a delegate to Tennessee's 1870 Constitutional Convention. Outside of politics, he wrote and edited several books on federal and state law. Subsection 3, the delegation of authority was made in the year of 1348, and in the next 50 years, the equity jurisdiction of the chancellor was clearly established. Subsection 5, equity ignores fictions, okay? Now, remember how we're talking about the at-law and inequity, the two jurisdictions that really matter? The at-law side is all fictitious. It deals nothing more than with fictions, okay, and commercial activity. The common law was then utterly incapable of doing complete justice in many cases, and if not in not a few cases, it furnished no remedy or relief whatever. It had certain rigid molds or formulas, into someone of which every cause of action had to be cast, And if the cause could not be run into any of these molds, there was no redress of grievance, all right? There was no remedy had. And if it could not be run into these molds, one of these molds, only such redress as the formula gave could be had, regardless of the equities of the case and the real rights of the parties in interest. The fiction, formalism, and arbitrary technicalities of the common law and its dialectical refinements were inexplicable and incomprehensible jargon to the public, and often a costly mockery of justice to the litigants. Those who asked for bread were often given a stone, and those who applied for a fish sometimes received a serpent. Equity, on the other hand, disregards the form, ignored the fiction, subordinated technicalities to the requirements of justice, and indulged in no dialectical refinement, ladies and gentlemen. Now do you see why I'm always preaching and teaching equity? All right? Its pleadings were simple and natural. Well, that's law. See, law is so simple that everybody unanimously across the board agrees with it. It doesn't really need to be taught. Murder, unanimously across the board, worldwide, is wrong. Everybody can agree with it. And you can express that in layman's terms. Every man can comprehend that. All right? That's what law is. Operating on an elevated level of morality. Okay? Its pleadings were simple and natural, and its doctrines were founded upon the eternal principles of rights as interpreted by a lofty Christian morality. Its great underlying principles, and now keep in mind, I know some of you guys aren't Christians out there. I'm not trying to force religion down your throat. I'm just talking about the higher spiritual morality, okay? And it doesn't matter if you're studying Buddha. I've studied a number of different Bibles, the Quran, different Bibles, all this different religious stuff, okay? And generally, and most typically, in most of these books, they all have the same concept of morality, doing right from wrong, okay? Now, the Quran speaks of some crazy shit, as does the Christian Bible, all right? Let's not get too carried away here. This Bible has some really perverted shit in it, all right? Where fathers are sleeping with their own daughters, all kinds of crazy shit, all right? But we're supposed to look into this and see between the lines. We understand and we comprehend by ascending of the mind the moral obligations that we have, all right? And its doctrines we found upon the eternal principles of rights as interpreted by a lofty Christian morality. Its great underlying principles, the constant sources, the never-failing roots of its particular rules were the principles of equity, justice, morality, and honesty, enforced according to conscience and good faith, and so adapted to the requirements of each case and the complications of business affairs, that the rights and duties of all the private parties were fully determined. Footnote 31, blind justice, with sword in one hand and scale in the other, condemning all in one scale and rewarding all in the other scale, is the divinity of the courts of law. Do you still want to be a common law? Where she's running around blindfolded with a saber and a scale, and she really can't see any of the evidence, and she can't hear any of the facts? Is that really what venue you want to operate in? I don't. All right? And I'm talking with first-hand knowledge, switching the venues and being in equity before. One time in my life, I've been in a venue that was private, okay? And there were just a very, very small amount of witnesses there. The divinity of the courts of chancery, on the other hand, is open-eyed equity, having neither sword nor scale, wearing the breastplates of good reason and good conscience, using both hands to remove all forms, cloaks, veils, technicalities, and subterfuge that conceal or distort the real facts and circumstances of the case before her, separating the pure grains of truth from the straw and chaff of fraud and artifice. Well, I just told you the at-law side is all dealing with fictitious entities, okay? The chaff and the fraud and the artifices. And apportioning to each party, whether complainant or defendant, what is good reason and good conscience is his just due. All right? Subsection 35. This is why I keep telling you to go check out Henry R. Gibson Suits in Chancery, the second edition, as well as the fifth edition. The fifth edition I found very powerful. Chancery has been the handmaiden of all courts in affording processes to meet exigencies. She has done so in the face of tyranny, to break loose the iron hand of power when grasping against consciousness. Okay? Blackstone died in 1780. You guys recall that I talked about Blackstone here and there in my prior videos. Blackstone was really ahead of his time, but in his later years when he started to discover equity, and not everybody agreed with Blackstone in his discoveries with equity, but he did start to see the concept. He did start to discover it. 1780s, before the valued lesson of mature experience in equity's limitless field were fully learned, Spoon's Shackett case, commentaries on the law of England were written and published 1765 through 1768, and Blackstone died in 1780, before the valued lessons of mature experience in equity's limitless field were fully learned. And it was a full century later that Parliament adopted the Equity Guarding Amendment of the English Judicature Act of 1873 and amended in 1875. Judge Murray Floyd Tooley of Illinois, Judge Tooley, during his long service as presiding judge, was regarded as the chancellor of the court. He was noted as the great equity judge. This sense of justice in the equality of men before the law, influencing him to regard the rights of the humblest citizen as great as that of the most powerful litigant. In such cases, his great analytical mind found the center of the tangle and rendered it a righteous decision. Regardless of the mere technicalities of the law, as a man, Judge Tooley was held in the highest esteem by every class of people. Remember how I was telling you there's two classes of citizens, the first class citizen and the second class citizen? And here again, even back then, during Judge Tooley's reign, as a man, Judge Tooley was held to the highest esteem by every class of people. He was modest and unassuming, yet bore himself with the dignity that became his position in society. Judge Tooley held his right of citizenship in high esteem, devoting much of his time, not required in the duties of his office, to civic reform. His impress is upon many of the laws of Illinois, made better by his touch, and Chicago is largely indebted to him for many civil ordinances he drafted. His lectures, Maxims of Equity, delivered before the Illinois State Bar Association, of which he was president, is masterly exposition of the principles governing equity proceedings, the equity jurisdiction in the modern 21st century. State courts, 1957 Supreme Court of Michigan, Hack versus Concrete Wall. Maximum, equity follows the law. This maximum, equity follows the law, unlike equity's remaining maxims, is limited in its application and operates within very narrow limits, adverting to Pomeroy. First Pomeroy, Equity Jurisprudence, 4th edition, subsection 427, page 796 through 797. The maximum is, in truth, operative only within a very narrow range. To raise it to the position of the general principle would be a palpable error. Throughout the great mass of its jurisprudence, equity, instead of following the law, either ignores or openly disregards and opposes the law, as was shown in the portion of the introductory chapter which deals with the nature of equity, equitable by nature. One large division of the equity jurisprudence lies completely outside of the law. It is additional to the law, and while it leaves the law concerning the same subject matter in full force and efficacy, its doctrines and rules are construed without any reference to the corresponding doctrines and rules of the law. Another division of equity jurisprudence is directly opposed to the law which applies to the same subject matter. Remember the conflict of variance between the laws? Okay? There's a conflict of variance between the rules of equity and the rules of law. And whenever there shall be a conflict between the rules of law and the rules of equity, equity shall prevail. Period. Its doctrines and rules are so contrary to those of the law that when they are put into operation, the analogous legal doctrines and rules are displaced and nullified. Continued, 350 Michigan, 118, 1957, 85, NW2D, 109, Hack versus Concrete Wall Company, docket number 89, calendar number 47,077, Supreme Court of Michigan decided October 7th, 1957, rehearing denied November 26, 1957, as to Robinson. We apprehend that it is more accurate to say that the case has never been challenged or overruled, and that it fully sustains equity's broadly exercised jurisdiction where the related remedies of reimbursement, exoneration, contribution, or subrogation are properly invoked, whether the suit be termed one for reimbursement or otherwise, the reason underlying equity's jurisprudence are the same. Continued. Pomeroy says, Fifth Pomeroy's, Equity Jurisprudence, 4th edition, Equitable Remedies, 2D, 2nd edition, subsection 911, pages 5,162 through 5,163. In general, under the early jurisdiction at law, in the absence of the express contracts for indemnity or exoneration, it was left to the caprice of the creditor to determine upon which of several parties bound for the same obligation the burden should fall, the loss being left wherever the creditor, by his choice of a defendant, might put it. This inadequacy of remedy on the part of the victim and consequent failure of justice became, however, a ground for the interposition of equity, and the proper readjustment of such burdens was, at an early day, an important field of equity jurisdiction. The effort of the courts of equity have been directed toward placing the loss as far as possible on the parties ultimately liable, or as between two or more not ultimately liable on the party whose liability is prior, and as between parties equally liable toward distributing the loss equally among them. The former result in research by an action for reimbursement, and the latter by an action for contribution. Both of these results are assisted by the actions for exoneration and the remedial process of subrogation. The text just quoted makes up the lead paragraphs of chapter headed Suits for Reimbursement, Contributions, Exonerations, and Subrogations, section 920, page 5183, in the chapters In the chapter pursues our search to fruitful end. We quote, subrogation, when an obligation is discharged by not only primarily liable for it, but who believes himself to be acting either in performance of a legal duty or for the protection of a legal right, or at the request of a party ultimately bound, and even in certain other cases favored by the public policy, where none of the above circumstances may be present, the party thus discharging the obligation is entitled to equity to demand for his reimbursement and subject to any superior equities, the performance of the original obligation and the application thereto of all securities and collateral rights held by the creditor. The same equity which seeks to prevent the unearned enrichment of one party at the expense of another by actions of reimbursement, contribution, and exoneration operates here by creating a relation somewhat analogous to a constructive trust in favor of the subrogee or party making the payment in all legal rights held by the creditor, and the subrogee may proceed to enforce the trust. Again, studying trust law is very, very important in order to prevail. And what I'm reading from is something that a man by the name of Rourke put together, and he's brilliant. I've had many of conversations with him at this point, And like he told me, I merely discovered what other men had already discovered before it was written in the literature. And there's a maxim out there that tells you that we would be so much more advanced if we would just pay attention to the older literature. And there's a lot of truth to that. I mean, these men were brilliant. Very, very brilliant. So, with that, I'm going to let you guys go. I got a lot of stuff I got to get done today. Thanks for joining me. Again, join selfgovernanceu.com. It helps me out. It helps me help you. We got some upcoming classes where we're going to teach about equity. We're going to be teaching about offsetting and discharging. We're going to be showing you how to discharge the credit cards. We're going to be showing you your right to recoupment, your right of subrogation, okay? Because of their unfair and deceptive trade practices, their manipulation of documents, their failure to disclose, none of the contracts are void, ladies and gentlemen. They are voidable. What do I mean by that? He who makes the claim has the onus of probandi to prove. All right, long suffering equates to acquiescence. So if you're gonna get your foot in the game, you're gonna have to be able to. You're gonna end up risking a little bit of something. Remember, you don't go to the craps table with nothing in your pocket and walk out of there with something. You got to put something up at the end of the day. And at the end of the day, put up your sins. Hang your sins on a coat hanger and walk in there pure of heart and come out there victoriously, standing on sound principles and doctrines. It can be done. I'm living proof of it, and I can help you get there. So thanks again for all your support. Again, this was out of a book that, a collection that Rourke had put together. Phenomenal work. For those of you that aren't familiar with it. And again, he's leaning off of Aristotle, Joseph Story, Pomeroy, Gibson, Judge Tooley, a number of other judges, decisions and renderings out of the exclusive jurisdiction of equity, which is beautiful, absolutely beautiful. So thanks again for joining me, and we'll see you later on this week. Have a good one.